Again, apologize for the delay, but I think hopefully it'll be worth the wait. So I'm just going to jump right in. I'm going to do short introductions to everybody. Professor Mueller is going to give an overview of his, partly based on a paper that he's written and this concept. Then I'm going to turn it over to our commenters for maybe 8 to 10 minutes each, and then we should have at least 20 minutes, if not longer, for comments from you all at the end. But one of the reasons I'm really intrigued by Milton's paper and this whole concept is that, you know, I think oftentimes if you remember, if you ever had a degree in public policy or any classes in it in graduate school, Chris, you teach these people, you know, they have this view there that, oh, we'd have these policy debates in Washington and they're discussed on the merits and on evidence and on analysis and on sort of this kind of technocratic view of the world. And in reality, a lot of these issues really aren't about technocratic issues or analysis. That's a component of them, certainly. But a lot of these issues really are debates about doctrine or worldview, ideology. Debates really that boil down in some ways to about what are the fundamental goals we're each trying to achieve. And I think it's important to recognize these debates because sometimes we just talk past each other because what we're really talking about are different goals, different value systems we're trying to maximize. We see that clearly in economic debates, but we see it increasingly in IT policy debates, whether it's privacy or copyright, telecom, net neutrality, a whole set of things. So I think I just have to share this with you. One thing that tells you how long this debate has been going on. I recently got hold of a copy of this. This is sort of like the "Thou shalt not copy that floppy" campaign. If you remember that, anybody remember these things? Remember that? I still have some at home. I think as museum pieces. But this was a campaign that the industry put together in 1984. "Thou shalt not dupe." So this issue of copyright and digital copying has been around for a long time. So let me jump right in. I'll introduce Milton Mueller. He's a professor and director of the Telecommunications Network Management Program at Syracuse University School of Information Studies. Has his PhD at University of Pennsylvania. Needless to say, I'm not going to read the whole thing. Expert on these issues of telecom policy. I've read his work for many, many years. Most recently has a book called Ruling the Root, Internet Governance and the Taming of Cyberspace, MIT Press 2002, and more recently, Internet and Global Governance Principles and Norms for a New Regime. After Milton, we'll move to, actually we're going to go out of order, and we'll move to Jeff Pearlman. Jeff is is a fellow, Equal Justice Works fellow at the advocacy group Public Knowledge, which is a group here in town most of you are aware of. It focuses on copyright issues and free speech issues. Jeff actually has one of these great backgrounds, which I think everybody should have if we're going to be in this space. He's actually a computer scientist and a lawyer. So he has a master's at MIT in computer science and also a JD from Stanford University in the law school there. And he has spent a year clerking for the Honorable Justice William Schwartzer in Northern District of California, joined Public Knowledge in 2007. And finally, Patrick Ross is Executive Director of the Copyright Alliance, which is a grassroots coalition of artists, producers, and distributors from across the copyright spectrum. He's also chairman of the Copyright Alliance Education Foundation. Prior to joining the Alliance, he was a senior fellow at Progress and Freedom Foundation, and where he dealt with intellectual property issues and the Center for Digital Property there. He also has a background in journalism with Communications Daily, an award-winning journalist, and also the founder of a website I think we should all commit to going to at least once a week, iCivility.com, which is a movement dedicated to improving online discourse. And I have to say, I think Patrick's very successful in virtually everything he does except that.
Just started that one, so give me a little bit of time.
All right, I'll give you 6 months, and if you don't change the discourse on the internet,
it's going to be easy.
It's going to be your fault. All right. So with that, Milton, do you want to come up here? Thank you. And can we dim the front lights?
I have to move this down after Robert is speaking, dwarfed by the man. So Again, my fault for not being here on time. It got into my calendar as 10 o'clock. I don't know how that happened. I was thinking that I had plenty of time. I was lounging around in a coffee shop and I got this call. So I got here as quickly as I could, and I apologize to you all for not being here sooner. Now, this is an issue that's intrigued me for some time. It started with my research for the Ford Foundation, in which I was tasked with studying public interest advocacy historically in the field of communication and information. And I began to acquaint myself with the social movement theory, which was a challenging new kind of literature for me to read. And I've always been interested in social change, social movements as an extension of policy, not looking at policy in a purely technocratic way, but also as something that reflects, popular sentiment and popular politics and ideologies. So what I became acquainted with was a movement. Some people debate it, but I sort of like to qualify it as a genuine transnational social movement. At the time I first wrote the paper that this presentation is based on, it didn't quite have a name. I think they're settling on this idea of A2K, of access to knowledge, as the common name for this movement. Of course, we all know it started with free software in the mid-'80s, which is a pretty long time ago. And this, you can look even at the internet developer community. The ITIF is one of the first open source software communities. And then this was extended to the copyright battles of the early or the mid-'90s with the Creative Commons idea, which basically extends the idea of the open source license into the copyright era. Then you have this idea of commons-based peer production, which is sort of a new mode of production behind free software and wiki and other kinds of things like that. And then you start extending the ideas of the commons of open source to physical resources, to network neutrality, to the radio spectrum. And of course there is a lot of resistance to patents and other forms of intellectual property. So if you look at this as a coherent movement, the question is, how does this movement define itself politically? What is its identity? So, on the one hand, you can look at this as an extension of, and a very high-level form of the liberal market economy. This is a voluntary, contractually constructed commons. The new GPL is actually based on copyright law. But it is kind of an inversion of copyright law, which says we are going to use contract to prevent you from privatizing a resource, which is very interesting. And of course, this is extended from software into a whole range of materials now, so that we have Lessig and his Creative Commons movement. On the other hand, you have a link, a political link, a symbolic link to the so-called peer-to-peer file sharing, various forms of copyright infringement, and a political sympathy between the openness movement, the A2K movement, and people who are resisting, if not downright violating, traditional notions of copyright. And indeed, there's always a border dispute about where copyright belongs and where it doesn't. It goes back more than 100 years. There's an early libertarian literature from these 19th century anarchists which says that if you're a true market libertarian, you don't believe in any copyright at all. That you have a natural right to copy things once you have it in your hands. But beyond those extremes, it's clear that there is an ongoing symbolic link between the idea of an open commons, the absence of exclusive property, and older industrial era communist movements. And so you see these kinds of parallels being formed. Now, once you're attuned to sort of social movement literature, you realize that this isn't just sort of amusing fun, and of course it is that. It is ironic. It's not entirely serious. But at the same time, these create an identity for the movement. These create a kind of linkages, not only intellectually and ideologically, but politically. And in particular, there is kind of a potential and sometimes actual link between the openness movement at the transnational level and the sort of anti-globalization, anti-capitalistic forces that are so prevalent in the late 90s, early 2000s. So, what is this all about? To me, it raises an intriguing issue about the role of private property, exclusive property rights, and the concept of a commons. And I'm intrigued by the way this discourse has been dichotomized, polarized, so that the two property regimes, property and commons, are counterposed as hostile and mutually exclusive things. And on one side of the debate, let's call it the left, the commons is presented as something, and note that it's the commons that they talk about, as if there's one big integrated totalitarian commons, totalistic, I shouldn't say totalitarian, that's a really bad word. So they say the commons, and this is presented as something public-spirited, it's all about sharing, and it's inclusive, and private property is denigrated as enclosure, as restrictive, as selfish. And on the other side of the political spectrum, the commons is equated with communism, with, you know, Marx and Lenin and Mao and all of these really evil mass murderers, or with overbearing regulation and the market. And again, we have a definite article here. There's the market. I've always wondered what the market is. I know what, you know, there's a market for securities, there's a market for taxi cab medallions in New York City. I'm always wondering what the market is. And again, so you have this polarized discourse in which property and commons are assumed to be mutually hostile entities. So the points I want to make today, fairly briefly in this presentation, I have two papers that I can distribute to any of you. First of all, dichotomizing the two is a mistake, that they in fact can be mutually complementary, that in fact neither can exist properly without the other. If you try to totalize the market, you end up with really bad results, and if you try to totalize the commons, you end up with really bad results. There are often positive interactions between the two. Our theories of political economy don't really do a good job of describing those interactions, and they need to adjust to take account of it. And our politics and symbols need to change. That is, I don't want to see us get stuck into a rut of reproducing 19th century politics where you have leftists who believe in commons and rightists who believe in property, when in fact most of the interesting things happen about when the two interact in some way. And the question is to find out how and where they should interact. So, to deal with this very superficially at the philosophical level, when I was investigating the free software movement, I found a tension between what you might call the religious view of free software and the pragmatic view, or what I call the deontological case for our commons, which is that sharing is intrinsically good, and the view that, no, we want to have a commons when, you know, it makes sense, that it helps us to undermine the dominance of a market player like Microsoft or something like that. So what I concluded was that the deontological case really leads to an all-embracing communism. There's no way to distinguish it. If sharing, you know, software is good, then sharing your house is good, sharing your car is good, and there's really no intellectual distinction made. And we don't want to go there. The pragmatic liberal case for commons in particular situations has a great deal of merit, and I think a great deal of practical utility that has been demonstrated over the last 20 years. And it's also true that exclusivity, like the commons, can be taken too far. And I'd like to talk about this in relation to the copyright and trademark battles, and particularly I'm most familiar with the trademark battles that have been fought in the context of the domain name system. So given the time constraints, maybe I'll just talk about that. But just to give you an example, as a sort of a free market-oriented person, I like markets. But I also know that markets are based on exclusive property rights, typically. But I've seen in these policy debates over copyright and trademark on the internet, it is very common for intellectual property claims to be taken too far in ways that create authoritarian structures. So, for example, I would use the attempt to push internet service providers into assuming various strong forms of intermediary liability, even to the point of using deep packet inspection to spy on people as they're using the internet in order to catch file sharers. This is a point where you're taking the protection of intellectual property to the point where it's authoritarian. Okay, I like markets because they promote freedom, or when they promote freedom. I don't like it when the attempt to defend the properties on which markets might rest leads to authoritarian results. And so in the trademark case, you've seen similar things where trademark owners, in some ways in a perfectly rational way, but you give them a centralized institutional infrastructure for defining and creating their rights on a global basis, and you find those rights expanding. You find them getting stronger than they were, than the economic and political rationale for trademarks really is. So you see things like reverse domain name hijacking. You see the globally protected marks list, which fortunately was a failed idea, and various kinds of extensions and projections of what are, at the micro level, perfectly legitimate rights. That is, you want people to have trademarks, you want those trademarks to be protected, you want to avoid consumer confusion and fraud, but in certain institutional arrangements, those claims to exclusive property can just be taken to the point where they are authoritarian in their implications. So, there's a lot of, I think, positivistic work. I've been talking normative. There's a lot of interesting positivistic work that could be done in this area. Theory rarely looks at the relationship between property and commons. They tend to focus on a particular resource and not talk about how it relates to other resources and other property regimes and other resources. So what explains why we get property or commons in a particular domain and how they interact? Well, you can get clues from Ostrom and Coase, at least that's where I've been getting my clues, and you tend to find two different explanations. Some people say it's the physical sort of characteristics of the resource, is it exclusive or non-exclusive? But if you look at that carefully empirically, there's all kinds of physically exclusive resources that we regulate as commons, and there's all kinds of non-exclusive ones, such as, for example, copyright, that we choose to make exclusive in various situations. So you get some mileage out of that explanation, but not a lot. And then also with transactions costs, you can find instances in which, yes, it's too expensive to create exclusive property rights, and this is the case that we see, for example, with unlicensed spectrum. It's horribly difficult and expensive. Not that you never want to do it, but in many cases, it's great to just say, this is unlicensed, you can enter the market, you can broadcast, and let's let congestion and conflict take care of itself through some basic technical standards. That's a lot easier than trying to define rigidly defined property, exclusive property rights that people can then trade in the radio spectrum. So that explains some things. But what an explanation I developed, and not in the article that you read, but in a different one, is that the strongest explanation for the existence of commons tends to be interest group contention. That is, when you have a political situation where there is a very big dominant actor that controls a resource upon which a bunch of smaller actors are dependent, you see the smaller actors gaining up on the big actor, sometimes successfully, and neutralizing that resource in order to create a more stable platform for them to use that resource and to prevent themselves from being strategically manipulated by the dominant actor. So this applies, for example, here's an example I developed, local long-distance access. We had a situation where we're introducing competition in the long-distance market. We still have a clear monopoly in the local market. What do? We create an equal access commons at the interface between the two, and we say, what does that do? That creates a very thriving market at the long-distance level for a decade or so. So you can view it as a short-term success. Although, and this is one of the interesting things, is that if you adopt a transactions cost theory of how this happens, the breakup of AT&T, I mean, the transactions costs were off the charts. Think of all the things we had to do: dismember the world's biggest corporation, create these weird entities called LATAs, enormous amounts of regulatory proceedings and cost studies. It was just a transactions cost nightmare. But we did it, and what explains that? It was the political demand of various interests at saying, we have this big actor, we want to neutralize the interface between a monopoly and a competitive market. And it succeeded, and the other interesting thing here is that once we created a commons at this equal access interface, after you got more competition, for example, mobile services offering long distance, the relevance of that went away, right? I mean, nobody cares very much about, maybe Mark does, but nobody cares very much about equal access to the local exchange now, because there are more competitive alternatives to the long distance provider. TCP/IP standards. Now this is a wonderful success story in terms of combining markets and commons, and I see the polarization in my debates with and participation in internet governance on a daily basis. So you've got people who say the internet is a commons, and you've got people who say the internet is a private market. And of course, it's both. What you have are open access, non-proprietary standards that form the basis for private networks to interconnect, and private service providers to provide proprietary services over these common standards. So if anything ought to make the case that there is a creative combination between private competitive markets and exclusive property rights on the one hand, and open commons on the other, the internet is it. Now there are some tensions. You know, when do we create common forms of governance over the internet, and when do we allow things to be proprietary? And what happens if proprietary practices or aspects start to intervene in the way the standards are formed? But on the whole, this has been a pretty good success story. ICANN is an example of over-commonizing the management of a resource. Okay, we've created an enormous collective decision-making authority, a common governance authority, over a pretty simple problem, which is assigning exclusive domain names at the top level of the root. And what do? We spend oodles and oodles of hours and free labor and to do what? To add a new domain name to the root. And what are the results? Well, you know, we said we're going to have private sector governance with ICANN. It's going to be fast, efficient, and lean, unlike those governmental organizations. After 10 years, we're maybe, or is it, no, it's 12 now, I forget, you know. In 12 years, we may be able to have defined a standard procedure for adding new top-level domains. And notice I say may. Okay. Now, a lot of these lessons could be applied to net neutrality, but since I don't think I have time, and that's probably the most controversial and interesting aspect of this, I think I'll leave that for the discussion. So net neutrality is interesting because, on the one hand, we have sort of the classic pattern for a commons governance arrangement, in the sense that we have dominant providers and lots of small people who want to gang up on them and neutralize their strategic asset so that they can use it more effectively. On the other hand, it doesn't quite apply because there's not just one big telephone monopoly. Neutrality was easy when we just had the AT&T monopoly, but if we've got 3 or 4 competing networks, including wireless and maybe two fixed, the case is a little more difficult politically speaking. Now, on the other hand, the idea of having non-discriminatory treatment of content, services, and applications is very appealing because that provides the groundwork for a thriving competitive market in these services. So both sides of this debate are actually not making a communistic argument, in my opinion. Both of them are saying, how do we get the benefits of a market, or how do we best get a creative combination of neutral openness and private exclusive markets? So I'll leave it at that. So here's an advertisement for our little project on internet governance. This is us at the Internet Governance Forum in Egypt last year, and I'll open it for questions. Or, excuse me, my responses, yes.
I always like leaving a presentation with a quote about Hegel. So, with that, Jeff, you can speak from there or from here. It's up to you.
I guess I'll speak from here just because what I have is sort of a smattering of responses to different parts of the article and to what you said today, and hopefully it will form some coherent whole. So let me start with the initial disclaimer. As Rob said, I'm a lawyer and a computer scientist. I am not an economist. I am not a philosopher. I mean, I like to think that I pay attention. I may or may not be a communist. I'll let you decide that by the end of today. I work for an organization called Public Knowledge, as Rob said, and we've sort of been involved in the heart of this info-communism debate. And sort of when it comes down to the question of rhetoric and whether it actually helps the dialogue, I think we're all going to agree today, I would be surprised if we didn't, that it doesn't help the dialogue to pull out 1950s rhetoric and try to paint one side or the other as using something that is as has been pointed out, really about Stalinist totalitarianism. That is what boils people's blood about it, and that is not actually the part of it that applies to what these groups are trying to do, or what these people are interested in, or what these norms are. And as Professor Mueller pointed out, we've appropriated a lot of the symbolism from communism for our own purposes, and usually in an ironic way. And I think so. I'm going to pull up an example of that here. So of course the next step in the Che Richard Stallman this is our legal director Harold Feld on our very own Public Knowledge Che Guevara T-shirt with on the back it says "Viva la FCC Revolution." So I think this gives you an idea, and those are for sale on our website. Every place is on it.
But you don't mind if we produce our own?
I believe this is on our website, and I would go there to confirm this before doing anything, that it is Creative Commons licensed, and you are encouraged to do what you like, which is subject to the restrictions of the Creative Commons license, which do rely on copyright. So it brings us full circle. But I think this gives you an idea of the place that the debate has gone, which is that, for the most part, we don't really encounter that in the day-to-day. We don't encounter people, slinging "you pinko FD communists" at us because I think it's ceased to be an effective form of debate or of rhetoric. So I think in that way the debate is moving forward in a very positive manner. I'm going to move this forward where I can go inside it from time to time. So we agreed that the answer, or I agree that the answer is finding the right mix. Now the question is, of course, what is that mix and how we go about finding it? And it's kind of interesting because we come from the point of view that there is a balance to be found in copyright. There's a balance to be found in all these things, but there are copyright abolition movements. And they're very small in the U.S. There's a very small copyright abolition movement in the U.S. There's a slightly larger patent abolition movement in the U.S. But if you go overseas, and I think you made reference to this, there are things like the Pirate Party in Sweden, and other far more evolved, far more developed social movements around these sorts of things. So to the extent that you describe it as a social movement, I think that's very true, and it's very easy to sort of dismiss that here in the U.S. because it hasn't, perhaps through the use of this rhetoric, it hasn't developed quite as far here. So I don't want to forget that in other countries they have these sort of things. They also have things like moral rights, which is something in the copyright context which looks a lot more like a pure deontological justification for copyright implemented through the law that says there are certain inalienable rights you have in things that you've created, that you always get a royalty on each sale no matter if you were involved in it or not, that you have certain rights to restrict what can be done with your works, they can be defaced or destroyed in certain ways, long after you've sold it, parted with it, and have no contractual interaction whatsoever with the people involved. So that there are a lot of ways to approach this other than what we have chosen to do. And of course, and I apologize for this, but I tend to approach this from the policy lawyer point of view. So I look back right to the Constitution and to where we've developed copyright from to try and figure out, well, was this, did this have a moral deontological basis, or were they consequentialists? And it says, right in the Constitution, Article 1, Section 8 is to promote science and the useful arts. So it's pretty clear that from that point of view, they had consequentialism in mind. But then you flip over to the First Amendment and free speech, and I think you find the opposite sort of thing, where it is there is a moral imperative that people need to be able to speak freely. And so when those two come into conflict, you get these really interesting questions of where we find the right answer. So let's see which of these is, given our time, most appropriate to talk about. I think one thing I want to point out is that there are all these areas that we brought up. There's spectrum policy, there's copyright, there's patent, there's open access to research. And all of these have very, very different properties. Some of them are rivalrous, some of them are sort of semi-rivalrous. Spectrum is a really interesting area that has very strange properties in terms of who can share it, how they can share it, and how its value actually increases over time. And so when we try to draw these parallels to the commons, it doesn't always work very well, and when you try to generalize rules to all of them, it's very easy to fall into a trap and come up with rules that don't have any sort of coherent basis in either ideology or sort of economic analysis for what's best. One thing I want to observe about what Professor Mueller said is that when it comes to things like the commons of the GPL, as he says, they rely on copyright. They rely on government intervention, and it becomes the sort of thing where it is a commons, but you have to agree to a set of rules in order to enter the commons in the first place. So there is this area of commonality, but it is subject to rules. It's not a completely, as I said, there's very little copyright abolitionism in the US. So, I'm trying to think how to phrase this. I guess the question comes, and this will bring it back to the net neutrality debate, when you have a commons that is done through sort of social contract and social agreement, and you get all these benefits from this commons, and at some point people in the commons or people running the commons, in the case of net neutrality, decide that they want to change the rules of the commons because the commons has now gained all this value. The question is, what do we then do? And if you look at the analogy back to original sorts of commons, at some point you either have to decide that it is an unregulated or purely privately regulated entity, or you have to decide that it has gained enough value and there's enough value in the structure that that is when we need to come in and regulate and make sure that we retain this value. So I think that's where we find ourselves in the net neutrality debate, or at least that's what we find ourselves arguing over, is that the internet is a great success story, and it does have these sort of elements of a commons where everyone is using these interoperable protocols. But it also has these elements of private contract where everyone can go out there and do what they want to do at the edge of the net. And so the question is, when someone wants to alter how they're interacting in the commons, is it to all of our benefits to step in and say, we've set up these rules, perhaps they were not legally enforceable in any way up till now, but they have enough value to society as a whole and to the market as a whole that we need to make them legally enforceable at this time. I think I'm going to hit one more point, which is that a lot of this question is about philosophy versus reality. Now, I'm not sure I buy the argument that you can't have a deontological basis for sharing is good in this context. You could, since you don't really need a consequential justification, you can say sharing is good for non-rival risk goods, whereas sharing is for my house is not good because I sort of don't have to justify. I don't think we need to go there because I think we do have very good justifications for why these things are good for society, good for us as a whole. And that's where we really need to come to, not necessarily what the justifications are, but what the reality of what this means on the ground is. So that's really where I'd like to come to this discussion.
Okay, thank you.
Patrick.
Okay.
I am going to go up here because I have a little PowerPoint that I made here. And in the interest of time, I will try to move through quickly. This is actually not the first page. Here we go. Also, some of you in the audience will be pleased to know I'm not going to mention ICANN. I'm responding here to, in particular, to the paper that Professor Mueller wrote, which I think is very insightful, and I would encourage everyone to read. I think there are 3 points that we also heard made in his talk. I would agree with both of our speakers that some of the terminology muddles the debate. There's more confusion than clarity. I, again, value his point that property rights and the commons can be, and in fact are interdependent and can build on each other. In particular, I'd like to pull out something he didn't focus on as much, and that is, this is a quote from his paper, that liberalism that takes maximizing individual freedom as its objective. His goal is to get to a commons, but he wants to get there, if I'm speaking correctly, through a focus on individual freedom and not just the larger sharing argument. This is important to me if you think about classical liberal is another word, right, that has developed different connotations. Here I'm thinking of the classical philosophical liberalism of John Locke, Immanuel Kant, and John Stuart Mill. And I'd like to come back to that in a moment. The paper focuses mostly on the open source debate, but as the professor here said, it's a much larger movement. And I particularly like the word utopia. I like to refer to people in this movement as digital utopians. And you'll see why in a moment. I think that's a more flattering terminology for them. You hear a lot in the current debate. Kevin Kelly, who's a longtime commons advocate, actually took ownership of some of this language last year and caused a bit of controversy. And yet you have a book that's just out. I would encourage everyone to read and legally download it or purchase it. Jason Lanier is one of the original Digerati. He was a leading virtual reality software developer. He's also a composer and recording artist. And he says he's been a believer in this movement to the commons, but feels that it is in fact sacrificing the individual. So I think it makes a lot of points relevant to this discussion. If we had more time, I'd go into them. Now the utopian movement, I mean, you could take this back to Plato, right? Ignore the shadows, go out of the cave and see the light. But the term itself, if we talk about Thomas More's book of his fictional island in this ideal world where you don't have property, everybody is equal, everyone's happy and has lots of leisure time, I think that's important. And here, if I could just quote this definition from the Oxford Companion, aims to overcome social inequality, economic exploitation, sexual repression, and other possible forms of domination. I would think that, Jeff, that you would probably be supportive of overcoming social inequality, economic exploitation, and other domination. I don't know your position or public knowledge's position on sexual repression. I do believe if anyone spent 5 minutes on the internet or looked at Craigslist ads, there is a certain liberalization going on there as far as sexual repression. We're not going to talk about that. I apologize that we're not. Yeah. That'll be another presentation. So something that emerges from the paper is this dichotomy of the spectrum of property rights and whether you focus on the individual and the community. And we heard from our other respondent about the Progress Clause. There's a very Lockean approach to that. Our founding fathers took that approach. James Madison took that approach. Locke was a big private property advocate, actually said that individuals can create their own property through the work of their own hands, which I think is very appropriate for individual copyright owners. Note I have it close to the communal box because, yes, it focuses on authors and inventors, but as you pointed out, it's designed to benefit society as a whole. And I don't have it on the far, on the y-axis, because in fact, right built in is a limitation, time. But I think that's the right quadrant to put it in. Jump ahead 30 years, we hear a lot about Luddites. I've been called a Luddite. Jason Lanier, believe it or not, has been called a Luddite. There were real Luddites in early 19th century industrial England, smashing machinery and burning down mills. And they were focusing on social inequality, but there were some great thinkers also focusing on social inequality that we now call utopian socialists. There's a great gentleman named Robert Owen, a self-made industrialist who, in his plans, was radical. He limited work to maybe 11 hours a day, gave them an occasional break, wouldn't employ children under 12. People just thought this was crazy, but his productivity went through the roof. Now, he took that another step. He sold all his factories, he moved to the land of opportunity, America, he bought land on the Wabash River, and Professor Note, he's trying to create a commons, but he used it through the purchase of private property. About 800 people moved into New Harmony, no property rights, everybody's equal, everybody contributes. Also, marriage was outlawed. Again, you got to get rid of that sexual repression and ownership there. Within 2 years, New Harmony had failed, people were starving. He sold the land for about 1/5 of the price. And one of his business partners had actually set up a whiskey distillery on the commons and was not exactly sharing his profits. So it's something to keep in mind. Now, if you jump to a few years ago, that's where I think our digital utopians emerged. People who are on the Whole Earth Electronic Network, right, the WELL, people like John Perry Barlow and John Gilmore, visionaries who said, you know what, the limitations of physical property are gone now. We have this infinite space, and ISP spending billions to lay pipe might argue with the infinity of the space, but there was a notion that we could finally have this world free of private property in a virtual world. So very much a communal focus on weak property rights. Now, since this is a policy debate in a think tank, I've shifted the y-axis to a government spectrum. For the most part, utopian socialists actually lobbied the government. Robert Owen, before he created New Harmony, lobbied for villages of cooperation that he wanted the Parliament and the Crown to create. They were going to be in the shape of parallelograms, these big commons, these communes. That became kind of a symbol because nobody had heard of a parallelogram before, so they thought he was a little nutty. That didn't track, and so that's when he did New Harmony. But you know, after that failed, he came back and he worked within British politics again, and our modern Labour Party actually owes a lot to the work that Robert Owen did. So there has been a long tradition of utopian socialists working within the government. Cut to late 20th century, I could talk a little bit about why I've got us in between. But if you look at the digital utopians over there, there's a strong libertarian streak. We heard that from our presenters. If you talk about oppression, there's corporate oppression and government oppression, and they thought they could be freed from both in this kind of internet space. There was a disdain of Washington. If you skip ahead a few years, I think this is where we are now. I mentioned EFF, Electronic Frontier Foundation. Early on, they actually created a Washington office here, as some of you may remember. And then the Barlows and the Gilmores got upset about that, and they shut it down, and we have the Center for Democracy and Technology now as a result. But they actually have a Washington presence now, and then there have been the creation of other organizations like Public Knowledge 7 or 8 years ago, I think, that are focused solely and heartily on public policy and working with regulatory agencies, lobbying Congress, lobbying the government. So there's, I guess, you would say, we'll go ahead and deal a little bit with the oppression of government if it can get us to the utopian world of social equality. I think it's important to keep in mind. So I don't think anyone could argue that the physical commons have failed. If you scale it down enough, you've certainly seen that. You could hang out in areas of Northern California and find very small ones that work. It didn't scale. The feeling was in the internet, you could scale this, you could have the whole world wired in this commons world, in a social equality world, an absence of property. I would argue that there are dangers to that. I think if you look in Professor Mueller's paper, you see dangers of that. I believe that there's a strong liberalism approach that gets you to the commons, and I just come back to the rivalrous, non-rivalrous example here. Can you make a copy of a rivalrous good, because that's the issue of property rights online. Another liberal philosopher, Immanuel Kant, wrote a paper where he said, and you could argue this is a moral rights argument, but it also is a free speech argument, and he mentioned the First Amendment. He said, you know, when you copy my words, I will acknowledge up front that I still have my words after you made a copy. So, of course, here we're talking about a reprinted version. He said, but now that you have that, you've actually taken my expression, you've actually taken my speech, and you've taken it without my permission. And that is not good for me. And he warned readers that if you're reading my words or reading other people's words, you should know that there may not have been consent given to those words. So I think it's important to keep in mind that there is, if we want to go broader, that there is that as well. There's the theft of ideas and expression, and I'll conclude with a passage from the Jason Lanier book. He says that as far as, you know, the non-rivalrous goods, digital copies online, there is an infinite amount of digital copies. But he says that there is a true scarcity of creativity from individuals, and the internet space needs to recognize that scarcity. Thank you.
Thank you, Ken.
One of the things that we try to do here is make sure that we have serious debates where we bring in Plato, Hegel, Locke, and beyond logical concepts. So I think we've all got our fill there. It takes me back. What I want to do is, before we open up here, I just want to let Milton maybe respond, and Jeff, maybe you want to respond as well to what Patrick said. But Milton, you want to respond to both our respondents and what your comments would be to theirs?
First of all, the idea that the rhetoric doesn't help the dialogue. I mean, I know this is not about sort of smearing people as Marxist-Leninists, totalitarian murderers. But the point I tried to make in the article was that these kinds of symbolism has an effect in terms of defining the identity of the movement, who its allies are, how it approaches issues morally or ideologically, so that you know, I would feel better, for example, if I heard the information left, in addition to their praise for commons, praising markets once in a while, when they think they're appropriate, and fighting for markets when they think they are promoting things. Because what I see in being engaged in these policy debates frequently is, you know, people just arrange themselves, they hear business, corporation, capitalism, oh, it's bad, or it's good, okay? And, you know, I think we got to get beyond that. The left has to move beyond its sort of Marx-inspired hatred of markets, and the right has to do the same with respect to commons. With respect to Patrick, I think it's a very interesting thesis that he's linking. To him, it's not about political economy, not about property rights, but about utopianism. But I would still maintain that the utopians that I see all have a political economic cast, which is typically hostile to individualism in the market. Although there were individualist utopians alongside Robert Owen, and there's a very good a book that I can't remember the name of, that treats all of these utopian movements in the 19th century, the individualist anarchists as well as the socialist ones, and looks at how they all fared. Of course, all utopian movements fail, and they all tend to become personality cults, because they're in effect the ultimate in strong government, because they are all run by one wise person. Now, maybe you could say that certain aspects of the internet community are like that, or were like that, but that's another story.
My wife's great-great-great-grandmother was a utopian leader. Jemima Wilkinson, and so she had this whole cult in upstate New York, and they asked her, do you believe in me? And they said, yes. Do you believe I can walk on water? And they said, yes. And she said, well, I can. And that was the end of it. They believed her.
Are you going to say she drowned?
No, she said she could walk on water, and then she did. Or they didn't need to prove that claim, because she said she could. Jeff, do you want to make any comments here before we open it up?
Sure, just one observation, and it's really about how it's not just the rhetoric, but that, and it's totally, completely inescapable, but the language you use to describe this frames the debate. So just a couple things that got said, and it's very hard on the fly, and I don't mean to pick on individual things that got said, but for instance, I think it was Kant you said was talking about how I still have my words, or somebody else copies them, but at the same time there's this theft of idea and expression. But once you throw the word theft in there, well, theft has different implications. Theft typically to most people means, oh, I don't have my thing anymore. So and I theft is coming to mean different things. Maybe theft now means copyright infringement as well. But just the choice of words and what those words have historically meant really frames the debate and can end up begging the underlying question and changing the ultimate meaning. So similar sort of thing in terms of being pro-market. The left needs to get away from its Marx-inspired hatred of markets, and you had an equally good description of the right. But of course, everything is in the middle. Plenty of the info-communists are extremely pro-competition, which inherently means that they respect markets and that think markets are a good thing. They just prefer competitive markets, and maybe they prefer regulation to achieve competitive markets versus deregulation to achieve competitive markets. But even the choice of the left-right dichotomy in there can occasionally muddy the waters when we're talking about these things.
Great comments here. I'll get a bunch here. You guys like in a cabal here? I'm only picking one of you.
We're talking.
We have different questions.
Mark, go ahead. Please identify yourself.
Mark McCarthy with Georgetown. Hi, Milton. I think your paper is wonderful for a lot of dimensions, one of which is to bring these philosophical issues to bear on the public policy debates. I'm not sure I like the pink tone of the slides, but I think your philosophical commitment to individual freedom, I think, in a way, might lead you astray in certain respects, and I've got two questions to focus on that. One is, on copyright, there's always been this dichotomy, and Jeff made reference to it, between the kind of utilitarian justification for copyright and the individual rights or moral rights justification for copyright. It strikes me that your emphasis on individual freedom focuses you more on the side of the moral rights as opposed to the utilitarian justification. So I think maybe some clarification there would be helpful. And the second is, on your discussion of the GPL, a similar point. You seem deeply suspicious of GPL because it winds up being an infringement on individual liberty. Here's a contractual way in which you promise, by signing the contract, not to engage in proprietary ownership. And you seem to find that to be a problem. It's as if people aren't free to give up their rights to control and own things. And so just a couple of clarifications there I think would help the discussion.
Yeah, no, I don't know what I said that made you think I'm deeply suspicious of the GPL. I think it's great. I think it's the granddaddy of the contractually constructed commons, and of course people have the right to contract into or out of that. And we had many debates within the World Summit, the civil society movement. There were people who were ideological about free software. This is one of the things that triggered this paper, was that if you were using particular kind of software that was not free software, they would not only refuse to cooperate with you, they would actively attack you on these email lists. It was like, okay, is this about freedom, or is this about a deontological commitment that you must be part of this commons? So that's what initially proposed the idea. And the other thing you said, yeah, moral rights. Again, with a commitment to freedom, individualized claims to control things that they do can in fact be inimical to the freedom of others, right? So I'm not very sympathetic personally to moral rights. I haven't thought deeply about how to make all of these positions consistent, but I'm not a big supporter of moral rights. And indeed, I often clash with privacy advocates because they believe, I think, in giving individuals too much control over, data that they spew out everywhere, and thereby are saying the rest of us are completely restricted in what we can do. And indeed, many of the privacy advocates have been turning towards forms of notice and takedown that sound a lot like copyright owners. So too strong of individual rights can be, I think, socially inimical to general freedom.
Unless somebody wants to comment, I'm just going to keep asking, so jump in if you want.
Add a very quick point, which is that you take that at the macro level. This commitment to freedom is something we're all very familiar with. We maximize general freedom in the populace by limiting freedoms in all kinds of individual ways, from copyright to simple things like it's not okay to hit somebody when you see them on the street, and that is limiting someone's personal freedom. But as a result, we are all freer for it.
Jonathan?
If I could just note on the individual, I don't think you have to conflate individuals and moral rights. James Madison certainly didn't, and so I'll take him on that.
Yes, Jonathan Zook from the Association for Competitive Technology. I appreciate the trip down memory lane in philosophy classes, but I guess I'd love to bring the debate back to a practical level. Which is that 90% of the time we're talking about copyright, it's about whether or not you have the right to copy Britney Spears' single and rather than pay for it. And so commingling that with a free speech argument, etc., seems a little bit disingenuous. And you look at, I think the Creative Commons has been an incredible force within the artistic community because it enabled choice. And it's the imposition of a different model, I think, that differentiates socialism from communism to some extent. So you now have the death of photojournalism because of Flickr. And yet at the same time, when somebody chooses to make a poster, the image they went to was one created by a professional photographer rather than one of the millions and millions of photographs that are now available under Creative Commons, which might suggest that there's in fact a quality differential between the works produced by professionals that have tried to make a living out of the production of copyrighted works. And so how do we juxtapose people trying to make a living through the production of these materials that you always have the ability to opt out of using, right? Listen to Christina Aguilera instead of Britney Spears, boycott the material if you feel like it's too expensive, rather than claiming some sort of amorphous free speech right to indefinitely copy works that with which people are trying to make a living.
We'll put that to Jeff. I think maybe that's where the question might be directed here. Patrick, I think
I agree with John.
I sort of the debate in your position is.
I somehow suspected that one was coming to me. So I think there's two very different stories you're telling there, and I think you're right on the one hand that when you talk about just using this as an excuse to copy a Britney Spears album instead of buying it, then you've got a problem. But I think in the end this is perhaps a moral question, but I think it's one that we, in general, as a society, have agreed on. That say that there is a limit here that you shouldn't just do that. The problem is that most of the debates, I think, are not really on that point, but they get into the nitty-gritty details of whether, when I take that Britney Spears album and copy it onto my computer, am I committing copyright infringement? Because part of what we're doing is we're trying to interpret laws that were written when these questions couldn't even be asked. So I think we have a problem with infringement going on, that there's no doubt. But the flip side of what you were talking about is things like Flickr, putting photojournalists out of work. But that's not a copyright infringement problem. That's not, for the most part.
Oh, I'm sorry, that wasn't my point. I'm saying it's an actual effect, and that's the market working. All this free stuff is putting photojournalists on a market. Right. And yet when somebody wanted to make an Obama poster, they went to the work of a professional photojournalist rather than using all of this free photography that was available.
Right, and that gets into the Shepard Fairey question of the Obama poster is a sort of complicated one, but it does raise a bunch of these issues in a very, very crisp manner. So, putting aside the question of the future of journalism and the future of photojournalism, what does it mean that he went to a commercial photograph versus a non-commercial photograph? And this is sort of something that you all have to do yourselves, is look at the photograph and look at the art and decide how much of that art, how much of the creativity came from the photograph, how much came from the art. And I've seen extremely compelling arguments made in both directions. So I don't have an answer to where that line is, and this is part of the problem. This is a line that we're trying to figure out how to draw right now.
And that's how, if I could cut in here, that's how I see the issue. It's not about the ethical basis for having some kind of copyright protection. I think almost everybody agrees with. I think even Richard Stallman at some point, agrees that if he or I write something on my computer and you want access to it, you have to pay me. The question is the systemic social mechanisms by which we define the boundaries of that property right and enforce it, so that, the Obama case is a very blurry line that's going to exist no matter how strong or weak your copyright is. I'm saying it can get too strong, such to the point that anybody who tries to make a move in the cultural arena is hemmed in and their freedom is too restricted. You've got to admit that happens. That when you have a Coke bottle, sitting somewhere in a motion picture you're making, you have to get permission from the Coca-Cola company. This seems to me to be ridiculous and have nothing to do with protecting creativity.
I'm sorry, I don't mean to dominate here, and I guess I opened a can of worms to bring up this poster, because there's issues about whether or not the creation of the poster was an infringement, and that's not the question I'm asking.
Yeah, right.
I'm saying with the non-commercial availability of thousands upon thousands of pictures of President Obama that could have been used by that artist to create that poster, why did he in fact choose a commercial image to make it? And does that suggest the possibility that there are in fact professionals, people who go to class to learn to take pictures, people that spend their entire career? And so what I want to really get to is the essence of how do I make a living in the copyright industry amongst all these philosophical debates that appear to really be about the fringes, as opposed to 90% of it, which is in fact the I don't know what the better word is, the unauthorized sharing or imposed commons on copyrighted materials. How do you juxtapose making a living with that?
Let me reframe John's question to maybe a specific point, because I think it's easy for everybody to say, yes, we all opposed downloading Lord of the Rings. We all oppose it. The question is, the real question is, what are you willing to give up to stop that? How much you as society are we willing to give up to stop that? And let me pose one hypothetical. I'd just be curious what everybody's position is. We just released a report on digital piracy beginning in December, and one of the clear things we identified in that is that there are websites out there that are clearly 100% about infringed content. There's no question about it. This isn't like, well, maybe half of it is. It's totally about pirated stuff, making it available. Would it be appropriate for the government to identify those sites and enable, not require, enable ISPs to block them so that people can't go to them and download illegal content, where there's no ambiguity? So that would be my question.
Yeah, and everyone should read ITIF's report, which has a lot of great ideas, and you encourage people to steal them, if I recall, in the title. I actually spoke on this at the Federal Trade Commission, and I showed some slides of sites that are commercially profiting from infringement. They use peer-to-peer, they put it up there, they charge you a monthly subscription. And I challenged everybody, shouldn't governments be doing something about that? And a fellow panelist was from the Electronic Frontier Foundation, and when he got up, he said, yes, I have to admit, that's wrong, and governments can play a role. So he went beyond ISPs. He said governments can play a role in shutting those down. I would not agree that everybody thinks it's wrong to download Lord of the Rings. If it's a virtual work out there, I think some people would argue, and I'd go back to your Britney Spears thing. You were talking about the idea of using a moral right to download. And somehow the moral right here got shifted to the author. And what I would argue is, I think the bad taste police should go after anyone who's downloading Britney Spears. But we talk about markets. The very definition of copyright is creating a scarcity, because you're giving the person control over distribution, reproduction, public performance. And the idea of a market is creating artificial scarcity. So it's unclear to me why once we move to an internet space, if we have rules that enforce artificial scarcity in the physical world, why would we suddenly abandon those in the digital world?
Milton or Jeff, do you want to respond to that? Or?
Yeah, just to use your specific example, just to keep this on a concrete level, I would support governments going after and prosecuting and arresting and taking down websites that are clearly illegal. I would not support using the ISP as an intermediary to block. If you identified them as a criminal enterprise.
My only point would be many of these are outside the U.S. where we don't have jurisdiction, and they're in essentially a lawless countries that don't want to enforce these things. So that's I should have mentioned that as the premise.
I understand that, and I make the same argument about child pornography even. I don't want ISPs to be used to block anything. I want governments to do their job and go after the criminals and prosecute criminals, and not establish block lists, because I think that creates all kinds of fallout that is almost uncontrollable, particularly when it's going on behind the scenes. We've seen that these block lists are secret, and when they're exposed, we find out what's on them. We're always very surprised. First of all, that they say, oh, we have to do this because it's in a different jurisdiction. Well, the Dutch block list, which a study was done, commissioned by the Ministry of Justice and hidden for several months because it was so embarrassing, discovered that 90% of the blocks were in the European Union and the United States, with which the Dutch have extremely extensive cooperative legal enforcement mechanisms with. So there's a pathology here. I'm objecting to your means, not particularly to your end. I'm thinking that's why we have to be careful about this, is that it's how you define and enforce property rights that affects the general level of freedom on the internet. It's not the principle as to whether there should be copyright. Although again, the issue of the term of copyright is another huge issue. I mean, why are we protecting things for 150 years? We know that has no effect on creativity. It's simply a rent that copyright owners are demanding.
So Milton, what's your regulatory mechanisms or means then to accomplish that end if you don't want the ISPs to potentially do it on a voluntary contractual basis with a content owner, which I think is a better way to do it? You don't like ICANN, I don't like ICANN, I don't want ICANN, I don't want the ITU, I don't want the UN to be policing this stuff. You're going to need an international governance treaty to deal with it that essentially takes all that down. If you say governments should do it, what does that mean?
That means that governments are enforcing their laws. Governments are enforcing their laws.
Mechanisms through ICANN, through because an ISP could do this today, take down certain types of peer-to-peer sharing sites or block them, and I know that there could be fallout from that. But what's the regulatory or governance mechanism? Are you saying the U.S. government should block the Great Firewall of America? Certain types of...
No, that's precisely what I'm trying to move away from. If there is an illegal entity in a foreign country, okay, you need to have, first of all, due process that dictates that they really are illegal, and secondly, once you have that due process, you should shut them down. I mean,
who?
Well, whatever mechanism works. But to say that
can you name one? I'm trying to wonder.
Well, there's an institutional vacuum, and that's why this issue is salient. It's precisely because we don't have a global government, right?
And we don't want one.
Well,
so isn't the ISP around?
We have a global government of domain names, right? And
you hate ICANN. I don't want ICANN.
No, but that's the point. Institutions are kind of like sausages. When you see them being made, they don't look very pretty, but in fact they have to do certain jobs. And do you want, you're asking for global governance, right?
No, I'm not. The opposite.
You think you are?
I think, yeah, I want to know what you're asking for when you say government should do it.
I think the question is, given the fact
jurisdiction
that Russia shows no inclination to change their ways because Russia is profiting from this as a country, it's an economic development strategy for them, what choice do we have? How would we address the fact that people are going to a Russian website today, downloading Britney Spears or Lord of the Rings, and if that's the question, Andrew, what do we do?
Can I jump in here just briefly, because I used to work at Visa and have an experience with exactly that case. where the intermediary jumped in at the request of the copyright owners to shut down a Russian website, allofmp3.com. In fact, payment services were removed from the website and had no ability to process transactions internationally. And Visa and the local bank that serviced the website were sued under Russian law and found guilty of improper contractual behavior because we'd withdrawn services without the appropriate sort of notice. So it's not easy to just say to the intermediary, you fix the problem, because that could potentially expose you to local liability under the law of the country that you're dealing with. The only real solution here, I think, ultimately, is government operation. The US government goes to the Russian government and says, if you want to really be a full player in the international environment, living up to WTO and WIPO and all those other things, you've got to play ball on the copyright area. So it's got to be government to government. It can't be.
And it has to be lawful.
It's got to be lawful.
It's not just.
But you just can't turn it over to the intermediary and say, you fix it, because then you put this huge burden on the intermediary to balance conflicting laws all over the globe.
Jeff?
Yeah, I think I would largely agree with what you said. And in fact, to do things like just cut them off, it's essentially a trade embargo. You're essentially just saying we are not doing trade with you as you're because we don't like what you're doing. You get into, I mean, I'm admittedly, I don't want to hide the ball here. I'm not going to answer your original question because it's been said, you know, what is it? Calling it complicated is oversimplifying. This is an extremely complicated problem, and you get copyright law is national, which means that if other countries don't have copyright law, then what we call infringement and what we think of infringement is actually just not illegal in that country. So that website may be completely legal in that country, and when you have an international communications network, you have to figure out how you're going to deal with these international governance issues. So I agree that it needs to be some sort of intergovernmental international cooperation thing. Now, we have to be really careful about how that's done. As we see right now with this ACTA, the anti-counterfeiting trade agreement that's being negotiated by USTR right now, in that particular instance, there is basically no transparency, or at least no transparency to the public in the US. And so this is a big issue that we've been fighting about, is trying to get transparency, because if these intergovernmental obligations are made, if agreements are made without public input, then we may not like the results. The other part of that is, one final point, is that when you talk about the government stepping in the US and saying, okay, well that website may be illegal, may be legal in Russia, or may not be legal in Russia, but use of it in the US is not legal, so we're going to block it. I think that is a path we have to be very, very, very careful treading down, because that is essentially government stopping speech. And while there may be instances where speech is not lawful and it is the role of the government to step in there, we have to be very, very careful about how that's done.
If I could just say, I was a little surprised at your response because you resist absolutism in your paper, but I just heard an absolute answer there that never should an intermediary do anything, despite what Adam was saying, or the hypothetical where it's a clearly illegal activity. I also heard that from you, and let me flip it around. It sounded like you were saying that we're talking about whether an intermediary would choose to act, or if it was asked to act, would it find itself in its best interest. What I heard is that if I'm running a pipe and there's clearly illegal activity going on my pipe, you would actually forbid me from doing anything and force me to continue to facilitate clearly illegal activity. And is that what you're actually saying? Would you prohibit an intermediary from actually trying to do target illegal on their
I wouldn't. I want to make that. I would, for example, let's take the Makolo incident where the ISPs basically on their own disconnected a botnet and spam center, control center. They just disconnected. Now, there was no government mandate. The government was supposed to be acting on this, but wasn't doing anything. But they have a competitive market. They're determining that these guys are harming their network, doing all kinds of bad things. They can, in fact, refuse to offer service to them as an extension of their, business contracts. What I thought I heard him saying was that the government can order all ISPs to block this site, that site, and that site, and create an officially mandated blacklist. And in fact, which would inevitably lead to a policy of using the intermediary to enforce, and which leads to a partition of the internet on nation-state grounds. I just view that as a really bad road to be going down.
Yeah,
just real quick, because we've only had 2 questions so far, so unless you want to, can you go ahead real quick, because I want to get more questions, and then we're going to stop.
So yeah, there are the 2 questions there, which is one, do we want the government telling ISPs which sites to block or not? But I think you were asking in this last one about whether ISPs should be acting sort of on their own behalf.
If they wish to.
If they wish to. And this is, this is a question that's coming up in the debates around net neutrality, and the SEC as a proceeding for open internet rules. And so it gets into very complicated details of the rules, but I think the general idea is that we have decided that as a general matter, our communications networks and infrastructure are too important to be left to the whims of the carriers. So we've implemented, and there's a long history of this. I don't know if Tim Wu's book is out yet, but he was writing a book on this point, on the history of common carriers. But we've decided that these are common carriers, that it's more important to have them carry everything and not make preemptive judgments about what to carry and what not to carry, and to allow some amount of illegal activity through. To do this now, in the telephone context, we have a rule that says no unjust and unreasonable discrimination. Those are the words. Now that doesn't say no discrimination at all. There are cases in which you can lawfully discriminate as a carrier, but in the same way that we want to be really careful about government censorship of speech and very careful about how it's done, we want to be really, really careful about how much leeway we give communications networks owners in deciding which speech goes with those communications.
It's so hard for me to resist as a moderator, so I'm going to indulge myself and just say, just to be clear, our position is actually, yes, the government should identify sites that are clearly there. There needs to be a judicial process, a clear process to do that, a regulatory process, the FCC or somebody, and we should block them, including child pornography and all sorts of terrible things that we don't allow in the real world. We shouldn't allow them in the cyber world. Chris, and then
Chris Miller, George Mason University. Just in the interest of thinking about this in a longer term than anybody put on the table this morning, it's perhaps useful to remember that the origins of copyright lay not in the right of the author to publish freely, but in a right conveyed by the monarch to the author giving permission to publish in the face of a general prohibition against publication of anything by anybody. And if you think about where this goes in terms of government controlling of who sees what, when, and where, maybe the 15th century is also useful to keep in mind as well as the 18th. But I want to ask a question about not about the contemporary policy issues, which I found very fascinating and don't understand at all, and am greatly informed by the debate, but about where Professor Mueller began this morning with his review of the social, cultural phenomenon of the digital communism, if you will. I think it's a bigger phenomenon. You might add to the list and think about how it changes the analysis. The open source movement in the industrial sector around industrial innovation, research and development part. And I don't think there are any communists or socialists operating in that realm, but they operate by a lot of the same rules. What was in the early days, go back to Berkeley units and so on, when people were freely contributing to software, who was paying for that? It struck me that there were enormous numbers of people who were ripping off employers by contributing freely. And that's never discussed in the debate. I wonder how that figures in your political economy.
Is free labor really free?
I think a lot of those people were, in the research and university arena, which is sort of, they were getting paid to do that kind of stuff. And some of them were government researchers, Berkeley units. Some of them were AT&T. Some of them were corporate. Somehow, this is not an issue I've thought a lot about, so maybe my answer seems superficial, but I don't, I think employers can monitor their employees, and that this is not a policy problem. If they find that their employees are spending too much time doing stuff that they don't want them to be doing, then they can fire them and get other employees. There was the other question.
I'm trying to get 2 more questions. So why don't we just Mark and then here, and then we'll stop. Mark.
Sure. My question is to you, Dr. Mueller. I love this concept of digital pragmatism, but I just feel like the past year has demonstrated how pragmatism as a philosophic operating principle can be a really dangerous one, especially in sort of social movement politics, which I think we're entering into here. I mean, groups like Public Knowledge and the EFF don't rate, they embrace these symbols for many reasons, some of which is to raise money, and these kinds of symbols and become part of what they want to be, and to sort of embrace pragmatism at that point might limit their effectiveness. So is it really possible to get to a digital pragmatism going forward?
Well, no, that's why I'm trying to define an alternative ideology that has the same appeal, or oriented around freedom in a broader sense that combines the two. Yeah, it's people are motivated by these symbols and by these polarizations. So if you can claim that you are the voice of the people and you're going to revolutionize society and sweep away the evil corporations, governments, whatever. Yeah, you're going to get more money and more support, and these professors that sit around drawing nice distinctions are going to get stampeded and left in the dust. But it seems to me it's not impossible to come up with cultural symbols which somehow embody a different way. And clearly I haven't done it. Otherwise I'd be wearing the beret and have my face on T-shirts. But maybe I'll get there somewhere.
No, not yet. One last question here. You had your hand up, aren't you?
Yeah, I mean, I was wondering just...
You want to identify yourself?
No, I'm sorry, I'm Mark Kennedy. I'm an independent consultant. I was just wondering how we can separate some of the issues here from just the general idea of creating a theoretical economic network. It seems to me that a lot of the reason people might go and try to create free software or so on is to create an economic network and simply get around the existing economic networks for particular types of software. And if that's true, then is this really a problem?
Is what a problem?
The whole issue
of property and...
Yeah.
Well, I think that relates to the point I forgot that the other man made, that there are in fact big businesses making what they call, emerges called property preempting investments. In other words, there is a purely liberal capitalistic case for having commons, which is one of the cases I discussed in this other paper in more detail. So it is a problem in the sense that when we have policy debates over things like net neutrality, or the proper scope of unlicensed spectrum, we need to have some conception, I think, of what is the proper mix of open versus proprietary resources.
Won't that mix sort of come out in an unfettered environment?
Not if your property rights regime forces you into one system or the other. If you can't do something because there's 16 different intellectual property lawyers suing you, or if it's too much of a commons and you can't get anything done because nobody can make any money, or there's 6,000 people involved in a governance arrangement that you have to convince, then you're in trouble. So I think we do need to have some theoretical conception about what really is going on here.
On that note, I was going to sort of discuss or try to sum up in some sort of coherent way with 3 or 4 paragraphs and all, but I think I'm just going to do it with the shorter thing and just say power to the pragmatists. That is how I summed up today's event, and please join me in thanking